there isn't much difference between 9.9 pounds of marijuana and 10.5 pounds of marijuana when it comes to size and shape. If we went along with the appellant's interpretation of the statute, Justin Wilson, the defendant in this case, the appellant, could have admitted to law enforcement, could have said, I thought that the marijuana that was being delivered was 9.9 pounds. And he could admit that, and he would still not be guilty of trafficking because the state has not shown.
I mean, you know, guilt could be culpability. The legislature could say, I care what the defendant knows, that it's a defendant who knows more than 10 pounds is more dangerous than a defendant who knows it's 9.9 pounds. Or the legislature could say, we don't care what the defendant knows, we just think people who deal with more than 10 pounds are more dangerous. But why couldn't a reasonable legislator do it either way? Why couldn't a reasonable legislator say, I don't think somebody who doesn't know that they're getting more than 10 pounds should go to prison as long as somebody who does know that? You're saying that's an unreasonable position a legislature could take? Because I'm betting you I can find a bunch of statutes that do require knowledge of that the defendant knows the weight or other characteristic of an item.
No, but in drug trafficking statutes, Your Honor, in this state and in other states, that's not the requirement. And
I hear you saying it's not the requirement, but before you were saying it would be an absurd requirement, an unreasonable requirement.
It would place an unreasonable burden on state. The state would have to show, one, either that the drug dealer specifically told the middleman, this is how much cocaine or marijuana I'm giving you, which rarely happens, or the state would have to show that the defendant weighed the marijuana, because there isn't much difference between 9.9 pounds of marijuana and 10.5 pounds of marijuana. To show the defendant's knowledge, the state would have to show the defendant put the marijuana on the scale. Let's take that to the logical conclusion. Did he calibrate the scale? Did he weigh the marijuana with the package or without the package? Those lead to absurd results, and that's one of our arguments. Your Honor, in conclusion, I see that I just have about a minute left. What we have supporting our position, Your Honor, is legal precedent. What the appellant has is grammar. What we have supporting our position is the legislature's intent. What the appellant has is grammar. What we have supporting our position is persuasive authority, persuasive legal precedent in our sister states. What they have is grammar. And
can I ask you one last question?
Yes, Your Honor.
Do you know if the Prosecuting Attorneys Council and the District Attorneys Association are aware that this case is pending before this court? This case would have enormous repercussions for prosecutors in the state of Georgia.
Absolutely, I agree. Just for some of the reasons I just stated, it would make it much more difficult to prosecute, especially the middleman.
I'm just surprised we haven't seen anything, you know, from prosecutors generally on an issue of this importance. You don't know if they're aware of it?
I'm not. Thank you, Your Honor.
Rebuttal for the appellant.
Thank you, Mr. Chief Justice. Briefly, I only have a minute and a half. 2 points. As an initial matter, willful blindness is not a defense to a knowingly charge. In fact, if knowingly is the standard, then this court and other courts have made clear that willful blindness satisfies it. There'll be charges on willful blindness, and you can't claim willful blindness as a defense. Secondly, if we are in the situation where the appellee concedes that the language is really subject to two constructions, which they have conceded. They said, yes, this is definitely a possible construction. Now, our position is that it's not, that we're right. But if it is a situation of two constructions, then, of course, the canons of construction should kick in for the defendant here. The rule of strict construction against the state and the rule of lenity. So if we are in that situation, then the tiebreaker really should go to us. If there are no further questions, thank you.
Thank you both for a very important case. Madam Clerk, will you call